Well, good evening, everyone, and welcome. My name is Darren Peterson, and I'm one of the executive directors here at the Cambridge Pro Bono Project, and would like to thank you all for attending our third CPP Speaker Series event for this term. By way of brief background, for those of you joining us for the first time tonight, the CPP is now in its 11th year and is a research program run out of the Faculty of Law at Cambridge, which partners faculty members and graduate research students with leading barristers' chambers, charities, international organisations and NGOs to produce targeted research on issues of contemporary social significance. We also aim to provide a network of here in Cambridge for students and faculty members with an interest in pro bono work and human rights. And to that end, last year we began a regular speaker series and are delighted to have Jason Pobjoy from Blackstone Chambers here with us this evening. Jason holds bachelor's degrees in law and arts, as well as a master in law from the University of Melbourne and a Bachelor of Civil Law from Oxford. And in 2013, he completed his PhD at the University of Cambridge. He's the author of The Child in International Refugee Law and has published widely in the field of human rights, public international law, and refugee law. Since leaving Cambridge, Jason has had an exceptional career at the bar, where he practices in a wide variety of areas, including EU law, public law, human rights, and public international law. He has appeared before the UK Supreme Court, the Court of Justice of the European Union, and the European Court of Human Rights. He also maintains a significant pro bono practice and has acted and advised a number of international organisations and NGOs, including the UNHCR, the Office of the Children's Commissioner, and the International Commission of Jurists. While undertaking his PhD, and importantly for tonight, Jason was also one of the founding members of the Cambridge Pro Bono Project, and we are extremely grateful to have Jason back with us this evening. Just a small housekeeping matter before I hand over to Jason. Jason will speak for about 30 minutes and then we'll have a Q&A session at the end. So please do post your questions in the chat box below. And then my colleague, Karcher Ackerman, who joins us tonight, will assist in asking Jason questions. So welcome, Jason.
Thank you very much, and for that very kind introduction. I first of all should assure everybody that I don't have a set of the All England law reports in my living room at home. I didn't trust my internet connection, so have made a trip into Chambers. A huge thank you for the invitation tonight. It's now been more than 10, well, it's now been 11 years since I was involved in 2010 in establishing the Cambridge Pro Bono Project. It was formally launched exactly 10 years ago in March 2011 by Professor Philippe Sands, who spoke about the importance of pro bono legal work, both as an academic and a legal practitioner. And the message that he conveyed at that launch is as true today in 2021 as it was in 2011. If anything, the importance of public interest pro bono work is even more significant given the ongoing cuts to legal aid in this country. Professor Sands is, of course, one of the leading lights in the human rights and public international law arena, and I certainly do not share his formidable wealth of knowledge or experience. Nor do I share the experience of some of the other speakers in the series this year. And I was kind of very honoured to be included when I saw the poster of the other speakers in the series. All of them were extremely eminent. What I'm hoping that I can offer this evening is some insight into the pro bono opportunities that are available as a junior legal practitioner. And I'm hoping that that will be particularly relevant to many of you who may well very soon be starting your career, whether that be as a solicitor, as a barrister, or in some other legal discipline. And as a platform for doing that, what I propose to do is to talk about some of the pro bono matters that I've been involved in over the past 15 years. In doing that, I hope to achieve three things. The first is to illustrate the very significant benefit that pro bono work can have to some of the most disadvantaged members of society. Second, to demonstrate the impact that pro bono work can have both on developing you as a lawyer, but also you as an individual. And thirdly, and really the key reason that I accepted the invitation this evening, is to try to encourage those attending this evening to take up the mantle and to explore the many and varied ways that you can contribute through pro bono legal work. And I imagine that in many cases, I'll be pushing very much at an open door, particularly for those that are already involved in the work of the Cambridge Pro Bono project. And I was thrilled to be told just before I joined this evening that the project currently has 6 projects on the go, which I think is just phenomenal. I'll conclude, as I said, I'll speak for about 30 minutes, and I'll conclude just with some very basic tips about how you might be able to get involved in pro bono work now and in the very early stages of your career. By way of very short background, as you may have already guessed, I am originally from Australia. As Darren mentioned, I just studied my undergraduate law degree in Melbourne. And throughout my degree, all I wanted to be was a commercial barrister that focused on defamation law. And I started off at a big city law firm, what was then Mallison Stephen Jacks. And like many of the Magic Circle firms here in the UK, Mallison's had a fantastic pro bono practice. And for the 3 years that I spent as a junior solicitor in Melbourne, I think pro bono work was probably about 30 or 35% of my practice. And it was that pro bono work that sparked my interest in human rights and refugee law. I hadn't studied any human rights or international law during my undergraduate degree, given I just wanted to be a defamation barrister. And it was through my pro bono work that I started developing this interest. So what I did is I went and did an LLM at Melbourne part-time while I was working, and I did all of those subjects which I'd done as an undergraduate in children's rights, in refugee law, in human rights, and international law, and that then inspired me to come and do some further postgraduate study over here in the UK, and eventually a PhD focusing on children's rights and refugee law. It was after completing my doctorate that I commenced at Blackstone Chambers, and here I've had a really varied practice, as Darren mentioned, with a focus on public law and human rights law. So turning then to some of the cases that I wanted to talk about, and I wanted to start with one which was quite a long time ago now that I worked on as a very junior solicitor, and it was one of those cases that first sparked my interest in human rights law and the kind of the UN system. It was a case called Nistram, a case involving a gentleman called Stefan Nistram, who was born on the 31st of December 1973 in Sweden. Now, he was born in Sweden by accident. His mother was an Australian permanent resident, and she was visiting her own parents in Sweden in the late stages of pregnancy, and Stefan came early. And so he spent the first 25 days of his life in Sweden before his mother took him back to Australia. And for the next 36 years, he lived in Australia with his mother, sister, and nephews. He held an Australian Medicare card, an Australian driver's license. He paid tax. He supported an Australian Football League team. At times he received unemployment benefits. At all times, he thought that he was an Australian citizen, but because his mother hadn't actually gone and had him registered, he actually was not. And he became aware of the fact that he was not in 2004, when, on account of some quite significant criminal offences, the government made the decision to cancel his residency and to return him to Sweden, notwithstanding the fact that, as I said, he'd only ever lived there for 25 days and spent his entire life in Australia. Now, as I explained, he had been convicted of some pretty serious offences, including the aggravated rape of a 10-year-old boy when he was 16 years old, and he'd spent quite a long time in jail for that. He applied for judicial review of the decision to cancel his visa, which was allowed by the full federal court, but that decision was then overturned by the High Court of Australia. And with no other avenues for domestic redress, he was returned to Sweden. He approached the Human Rights Law Centre in Melbourne, which performs a similar role to the Public Law Project here. Does some terrific pro bono work, often teaming up barristers and solicitor firms. And I worked with them, with a leading and junior counsel and a small team of solicitors at Mallisons, and we submitted a communication to the Human Rights Committee, which monitors, as many of you will know, compliance with the International Covenant of Civil and Political Rights. We submitted an application for interim measures to try to avoid his return. That was rejected. And so we then lodged a full communication in early 2007. Some 4.5 years later, in August 2011, the UN Human Rights Committee published its final view and found that Australia had violated Article 12.4 of the International Covenant, which protects the right to enter one's own country, and Articles 17 and 23, which provide protection from arbitrary interference with family life. The committee considered that the threshold question was whether Australia was indeed Mr. Nistram's own country. It held that there are factors other than nationality which may establish close and enduring connections between a person and a country, connections which may be stronger than those of nationality. The committee considered that Australia was Mr. Nistram's own country in the light of the strong ties connecting him to Australia, the presence of his family in Australia, the language he speaks, the duration of his stay in the country, and the lack of any other ties than nationality with Sweden. While the decision is a watershed one, its core premise is reasonably straightforward: the uprooting of an individual from the only home that he has ever known, severing contact with his family, friends, and regular employment, and deporting him to an entirely alien environment where there are no genuine prospects of meaningful interaction, constitutes a violation of basic human rights. The committee held that as a party to the optional protocol to the ICCPR, Australia was bound to provide Mr. Nistram with an effective remedy. And in the committee's view, this would require allowing Mr. Nistram to return to Australia. The committee also held that Australia was under an obligation to avoid exposing others to similar violations in the future. There were three specific points that I wanted to highlight from this case. And the first is that it was a fantastic example of teamwork, and specifically an NGO, the bar, and a solicitor firm working together. The NGO was in the driver's seat, often having the client contact, and the NGO brought together a team of barristers and solicitors. It's an extremely effective model, and it's one that's used over here a lot. It's becoming increasingly common, and you'll see that from some of the other examples that I'll discuss. But there is a really wonderful culture over here at the bar, and I think particularly at solicitor firms, where solicitors are willing to contribute huge numbers, hundreds and hundreds of hours of solicitor time to work on pro bono cases. And I just think that it's fantastic, and there are great NGOs that will often find the cases and then bring together these teams. And so that was a really early example of that happening, but it's what happens. It's very common to happen today. The second point is to highlight that this case was in many respects quite an unattractive case because of the nature of the crimes that had been committed by Mr. Nistram. And it really, I emphasize that because it emphasized the importance of everybody having representation, but there was also a real hurdle. You have a magic circle firm that is concerned about its reputation. Whenever I wanted to pitch a pro bono case, I had to go to a pro bono committee and make my case. And here I had a 37-year-old man who, when he was 16, had raped a child, and I think had spent 19 years in prison. So when he was 16, he raped a 10-year-old boy, and had spent a very significant amount of time in prison. And I still remember having to turn up to this committee to make the case, and I started with all of the facts that I outlined, which was born in Sweden, 25 days, and then spends 37 years of his life in Australia, knows no other country, speaks no other language, and is about to find himself in a completely alien environment, an extremely important point of law, and an individual that has no other recourse to domestic remedies and wants to make this communication to the UN committee. And to the credit of the committee, kind of the outrage that sparks when you outline the facts didn't dissipate when I explained the factual background, and they were very willing to take on that case. And again, I find that attitude mirrored here, where you see the big city firms very happily taking on very controversial cases. And I think that that's fantastic. And they're not worried about the Daily Mail headlines, and they're content and often very, very happy and very, very willing to put their name to important public interest claims and issues, irrespective of the identity of the individual or individuals involved. The third point that I want to flag, which is slightly less positive, is that despite the best efforts of the pro bono team, justice can sometimes be very, very slow and not always effective. So in this case, it was 4.5 years to get a decision from the Human Rights Committee. Moreover, as many of you will know, those views of the UN Human Rights Committee are not binding, and and even though the Australian government has assumed an obligation to cooperate in good faith with the committee and to provide an effective committee, its official response to the Human Rights Committee when it published this view was that the Australian government respectfully disagreed with it. And to this day, Mr. Nistram remains living in Sweden. So he didn't get an effective remedy, notwithstanding that decision. That decision, though, as I have said, has become a watershed decision with far-reaching consequences, and it's one that I certainly have quoted and cited in a large number of cases since, and it was a really important development. And hopefully, even if it hasn't helped Mr. Nistram, has had an impact in other cases, in both in terms of UN jurisprudence and domestic case law. The second set of cases I want to talk about will involve interventions that I have done for UNHCR. So the UNHCR in the UK is particularly active in the UK courts and has a really important supervisory role in terms of the interpretation of the 1951 Refugee Convention. And it regularly seeks, in appropriate cases, permission to intervene in cases which raise issues concerning the interpretation of the convention, and it has a long-standing relationship with Baker McKenzie, which provides solicitor support and draws on a team of pro bono barristers. It doesn't make submissions on the individual facts of cases. It deals with points of principle to assist in the principal development of international refugee law. So I've acted in two cases for UNHCR. The first case, a case called AH Algeria, was a case in the Court of Appeal that involved the interpretation of Article 1FB of the Refugee Convention, which precludes individuals who have committed serious non-political crimes from obtaining refugee status. And in that case, it involved an Algerian national who'd been convicted and imprisoned in France for falsifying administrative documents and being a member of an association formed with a view to preparing acts of terrorism. After he'd served his sentence, he applied for refugee status in the UK. It was accepted that he had a well-founded fear of persecution if he was returned, but he was excluded by operation of Article 1FB because of the crime that he had committed. And in its detailed submissions, UNHCR submitted that the core rationale of Article 1FB was to ensure that the refugee framework did not stand in the way of serious criminals facing justice. However, where an individual had served his or her sentence or had otherwise been rehabilitated, that rationale doesn't apply. And so exclusion from international refugee protection is no longer required. Now that argument, unfortunately, even though it has been accepted in other courts around the world, wasn't accepted by the Court of Appeal here. The second case, SXH, was heard before the Supreme Court, and that case concerned an individual who had used false documents in arriving into the UK and had been prosecuted for that. And UNHCR made a series of detailed submissions to the court focused on Article 31 of the Refugee Convention, which provides that a refugee should not be subject to penalties for unlawful arrival. And the key issues in that case were whether a prosecution in itself, as opposed to jail term or a fine, constituted a penalty. And the government's position was that a prosecution, which led to an eventual acquittal, did not constitute a penalty. And UNHCR submitted that that was contrary to the language, context, and purpose of Article 31. 2 points about these two interventions. And the first really is about intervention work more generally. A very significant part of my pro bono practice involves intervention work for NGOs. And these interventions serve a really invaluable role in providing assistance to courts because they enable the courts to hear arguments, often from expert bodies, that raise wider issues of importance beyond the individual interests of the parties before the court. And UNHCR's intervention work provides a really clear example of that. Its submissions, drawing on its institutional expertise, focus squarely on issues of principle, and they're able to draw on their knowledge in the context of the interpretation of the Refugee Convention, their knowledge of how those provisions have been interpreted in jurisdictions all around the world, which helps to inform kind of a common understanding of this international treaty. For those who are interested, there is a really fantastic publication by Justice and Freshfields on interventions more generally, practical tips on how best to make them, etc., but also setting out just the real valuable contribution that these interventions can have. The second point is, again, which relates specifically to UNHCR, is it's fantastic to be involved in these cases because they do have an impact well beyond the individual case before the court. So a huge amount of work and effort goes into these individual interventions to make sure that they are entirely consistent with what's been said previously, to make sure they fit into, they're consistent with the kind of institutional position of UNHCR, and to make sure that they could be valuable in terms of providing guidance in other cases. And these are all published on UNHCR's website, and you often find in one intervention you'll be citing an intervention from another case, etc. So they have the capacity to have an impact beyond the individual case. The third case that I wanted to look at in detail, and then I'll run through a few others just much more briefly, is a case of RA. And this case involved a 45-year-old Nigerian woman who had a 5-year-old son, and I'll refer to the son as RA. And this was a case that was kind of quite close to my heart because it touched on many of the issues that I addressed in my doctorate involving child refugees. And the mother had very poor mental health, and there were multiple instances of self-harm. And so the child RA had been taken away from the mother for, I think from memory, a period of about 9 months. They were both migrants. She'd applied as a refugee, as from memory, as a former prostitute, and she felt that she would be at risk if returned to Nigeria. And so her son was taken away from her. She was admitted to a psychiatric institute. And after 9 months or so, after she'd recovered, her son was returned to her. Her refugee claim had by that stage been rejected, but the Home Office hadn't taken any steps to deport her while she was removed from her child. However, shortly after her and her child were reunited, they were both deported to Nigeria. And this was despite the fact that the only reason that the child had been returned to the mother, or one of the key reasons the child had been returned to the mother, was because of the support network that they had around them. So the foster family that had been looking after the child had agreed to kind of continue to play a role. There was a really strong supportive network at the school that the child was at. But none of these things were taken into account, and they were just deported and left at the airport in Nigeria. And I was approached to act for the Office of the Children's Commissioner, who was very concerned about the lack of any form of independent assessment of the needs and best interests of the child in the process. It was just a case of the mother's refugee claim had been rejected. And so the whole family unit, mother and child, had to get returned. There was no consideration of the potential risk to a child being removed with his mother, who had known mental issues, without any form of support network in Nigeria. And we submitted there were two key issues in this case. And the first was that the child had been rendered entirely invisible in this process. And I was able to draw on a lot of the work that I had done in my doctorate about the importance of participation of children in decision-making processes, drawing on the Article 12 Convention on Rights of the Child jurisprudence. And that argument was accepted by the Upper Tribunal, which held that notwithstanding the fact that no separate claim had been expressly advanced on behalf of the child, the circumstances may be such as to warrant independent assessment by the decision maker. Effectively, the decision maker, there's some form of shared duty of fact finding, and the decision maker should have proactively considered the interests of the child. The second issue, so once you get past the issue of invisibility, and so you do shine a spotlight on the child and the child's interests, was, well, what do you need to do? And we said you need to consider the best interest of the child. And in the UK, as some of you may know, Section 55 of the Border Citizenship Immigration Act requires the Secretary of State in any decision involving a child to treat the child's best interests as a primary consideration. And we say that wasn't done. There is no conceivable way that you could say that returning a child in these circumstances is consistent with the child's best interests. Now, the government would ordinarily say, yes, well, that may be right, but it's only a primary consideration, and it can be outweighed by other factors, including immigration control, etc. The problem here, though, was because they completely ignored the child, that assessment just wasn't done. And so we managed to get, as some of you may appreciate, it's very difficult to prevent the deportation of a refugee. It's much more difficult to get an order compelling the return of an individual, but we got that. We got a mandatory order compelling the mother and compelling the government to bring back the mother and the child. The government appealed to the Court of Appeal kind of very urgently. They didn't appeal on the substance, they just appealed on the relief. They said, no, well, we'll undertake the best interest assessment, but let's leave them over there. And we said no, and the Court of Appeal agreed. And so they were returned, and I'm very happy to say it took a number of years, but the best interest assessment has now been undertaken, and no surprises. The Home Office has now found that they get to stay. So it was a really terrific result. A key thing from that case, and when I talk about that case with other colleagues and kind of more junior members of chambers interested in pro bono, is if you do take on pro bono work, you need to treat the client as if they are any other client. And it's the golden rule for me. And if you don't have expertise, you shouldn't take it on. If you don't have capacity, you should not take it on. You cannot do a substandard piece of work simply on the basis that it's not paid. And this client got gold star service. So within 3 hours of my being contacted by the Office of the Children's Commissioner, we had Freshfields on board who were just phenomenal. Monica Kars-Frisk, who is the head of Blackstone Chambers, was the silk in the case. And we put in hundreds of hours of work. Another silk came on later as well because Monica wasn't available for hearing. And hundreds of hours of work went into the case. We turned up at the Upper Tribunal kind of on these little desks with all of our beautiful Freshfields bundles, and I think we had 4 or 5 solicitors behind us, senior associate, a couple of trainees, a couple of associates, Silk Junior, detailed submissions, and we got a fantastic result for the client. And I think it's really, really important in any work that you do that's pro bono that you do treat them exactly the same as a paying client, and that's a nice example of exactly that being done. That's just a snapshot, and it kind of covers a very long period of time from my first year working as a solicitor to some of the more recent cases. Just to give at a very high level some of the other, particularly some of the more recent work that I've been working on. Well, during my time at Cambridge, I did quite a few of the CPP projects, of course. Since starting practice, I've done a large number of interventions in the Court of Appeal and Supreme Court. I've acted for bail for immigration detainees, medical justice, the Equality Network, Detention Action, Anti-Slavery International, the Air Centre. These matters have ranged from issues such as the detention of mentally ill individuals, transgender rights, the right to keep gender history secret, the right to family unity for refugees. Very recently, I was instructed by the UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism in the Shamima Begum case. And I did that both in the Court of Appeal and in the Supreme Court. The Supreme Court's judgment, for those interested, is being handed down tomorrow. That was a hugely interesting case. We provided, the Special Rapporteur provided really focused submissions on the concept of arbitrary deprivation of citizenship as a matter of public international law and customary law. So, and it was really nice actually, because I did that with Professor Guillermo Verderame, who is a QC at 20 Essex Street, but was also my PhD supervisor at Cambridge. So it was really nice to work on that together, and we did that pro bono with Lee Day as the instructing solicitors. I've done a very large number of pro bono cases in the European Court of Human Rights. Recently had a terrific judgment just a couple of months ago on the protection of lesbian women from private acts of violence in Croatia, where we won against the Croatian government. Again, that was an example of slow justice. I think we put out in our application about 6 years ago. That was for the Air Centre and a number of other NGOs. I was involved in the KU case, which went to the Supreme Court, and then we took that to the European Court of Human Rights about the massacre in 1948. I'm currently acting for a coalition of LGBT NGOs who are intervening in the Tavistock case, which is in the Court of Appeal, involving the use of PUV blockers on children. I do a lot of work for the Air Centre, and I'm now on the board of the Air Centre in the Immigration Tribunal. So their first instance cases. A lot of the bigger intervention cases I'll be led by Silk. In these immigration cases, I'll do unled. My current case for the Air Centre involves a 19-year-old man who got kind of caught up with a gang when I think he was 13 or 14, and kind of tragically killed a man and was in jail for 6 or 7 years and is now at risk of deportation. And again, he's only ever lived here other than for a few years. And so we're challenging that deportation decision. The work, as hopefully that gives a snapshot of, that's all pro bono. It's very varied. In most cases, it has very significant implications for the individuals concerned, and sometimes it has much broader implications. The case that I just mentioned with the 19-year-old man, his whole family's here, he's in a relationship here, and he has this threat of deportation hanging over his head. And that's something that hopefully we can avoid. The work is rewarding, both personally and professionally, and it has my pro bono practice, because it does involve quite a significant amount of what I do, it has a really large impact on my day-to-day employment. At any time, I'll probably be working on 4 or 5 pro bono cases, normally involving issues that I'm quite passionate about. My husband often remarks, well, that I used to bounce to work. Now I kind of bounce to my little study. And that's in large part because of this work that I get to do. Now, I would be being very dishonest if I said that I spent every day doing important, exciting pro bono work, and that's not right. I do need to make an income, and I combine my pro bono human rights practice with a broader practice which incorporates commercial and competition work, and it really is all about balance. But that's what's fantastic about chambers like Blackstone and many other chambers, is that you are able to have that balance. You can have some commercial paid work or commercial public law work, and then have a lot more flexibility in terms of other work that you take on. I think in addition to being rewarding and having a positive impact, I think there are also some tangible professional benefits which can be derived from undertaking pro bono work. I think it's made me a much, much better lawyer. I have had to be very fast learning, and have had to get across many areas of law very quickly by kind of putting my hands up very quickly to some of these cases, and they often moved very, very quickly. It's given me a lot of opportunities for advocacy that I would have normally had to wait much longer for. It's allowed me to develop really lasting and wonderful relationships with NGO clients, and the Air Centre is one of those. The very first piece of work I did for the Air Centre was the Croatia European Court of Human Rights case, and I've now done probably 5 or 6 interventions for them, a very large number of kind of immigration tribunal cases for them, and I'm now on their board, and I just think they're a fantastic organisation, and they're a wonderful client. The pro bono work that I've done has also allowed me to kind of work with and learn from some of the most incredible senior advocates. And for my first kind of 8 or 9 years in chambers, I did a huge amount of pro bono work with Mike Fordham, now Mr. Justice Fordham, and Diana Rose QC, now president at Magdalen College, and I've just learned the most extraordinary amount from them through these pro bono opportunities, and being willing to put my hand up and say yes, basically to every opportunity that came through the door. And similar benefits would apply whether you are a solicitor or a barrister. As a solicitor, I got there were some lead pro bono partners I got to work with, but then I also got access to lots of members of the bar that would form part of various pro bono teams that were involved in. I got to work with a lot of other solicitors from all different departments rather than just litigation that were interested in the pro bono work. So lots of positives as well as the broader societal benefits. I said I conclude with just a few tips and about how to start getting involved now at this stage and also in the early stages of your career. And so the first is to get involved now, and this is me kind of waving the flag for the Cambridge Pro Bono project. And I imagine that many of you, and the fact that you were interested enough to kind of come along this evening, suggests that you may well already be involved in the work that the project is doing. You could also look at volunteering and turning over summer breaks. And once, if you're going down the bar route, there are, while you're doing the bar course, there are a number of opportunities that are available to allow you to start getting on your feet and getting advocacy in the pro bono sphere. The second point I wanted to make is, if this is something that you are very passionate about, it's something worth keeping at the forefront of your mind when you are looking and exploring job opportunities. So if you're looking at solicitor firms, it's worth having a look on their website to get a sense of what sort of pro bono opportunities those firms offer, asking the questions in your interview. And you'll find that most firms are really proud of their pro bono work and the impact of their work and the policies that they have in terms of involvement of juniors, etc. So you should ask questions about those opportunities. If you're thinking about being a barrister, ask chambers kind of how supportive they are of pro bono work, etc. I'm sure the answer will be that it's encouraged and supported. That's certainly the case here, and certainly the case for every other set of chambers that I've ever come across. And the final point is just to be proactive, be creative, think outside the box. Don't just wait for somebody to call you and ask to do this work. If there are particular issues that you're passionate about, find out the organisations working in those areas, make yourselves known to them, and let them know that you are keen and willing and able to do the work for free. That's certainly what I did at kind of early stages of my career with a few organisations, just letting them know that I had this expertise. That said, I was really keen to try to work in the area that I had spent 3-4 years studying, which was involved refugee kids. So I reached out to some of the organisations working in that area. So that's all I really had. I didn't want to spend, I've probably gone over half an hour anyway. I didn't want to spend too much time because I'm hoping there'll be some questions, and I'm very happy to answer anything.